Hello, my name is Georgianne Ford with the Alpha Center for Divorce Mediation, and we have one of our attorney mediators back with us today, Christine Lombardozon. Welcome back, Christina.
Thank you. How are you, Georgianne?
Good. Christina, your topic today has to do with how child support is figured out in Lehigh County specifically, but I think you're going to give us some other expansion on that.
Yes.
So
I'll try to be brief. But just so you know, as a preface to this recording, child support is pretty complicated. Like, I won't be able to cover everything in this short little video. But I'll kind of give you like a high level overview of, what you can expect if you have to deal with child support in Pennsylvania, and then primarily in Lehigh County, if anybody's local. But for the most part, a lot of the counties kind of work very similarly.
Okay.
So the first thing people need to understand is both parents have a legal obligation to support their children. So there's a legal obligation. You have that until the child turns 18 or graduates high school, whichever comes last. And at that point, after that, you have no legal obligation. But prior to, you have a legal obligation to provide them support.
Okay.
So
can I just ask a quick question? So if a child is intending to go to college, that doesn't matter. That's not mandatory.
Right. And a lot of people think about that. In Pennsylvania, we do not have to pay for college. However, there's case law out there that suggests there's certain cases where if the child relied to their detriment, based on promises that parents made, a court could potentially enforce it. So it's not necessarily you're free and clear of supporting your child. But if nothing's ever been said, right, like I'm going to pay for your college, then at the age of 18, you're pretty much free of your obligation.
Yeah.
But there's other states where it's different, and parents would be on the hook for children's college and post-secondary ed.
Nice.
So Pennsylvania, though, uses the income shares model, which a lot of other states use. I think 36 other states use it. And really what that means is that a child should be expected to receive the same amount of financial support that they would receive if both parents were living together and were married. Right. So once they separate, the child should basically be treated the same financially, if that makes sense. Mm-hmm. Now, for most people, it's not a problem because usually there's parents trying to kind of buy their way back into their child, and so they give them more. Mm-hmm. But I think we all know that doesn't always play out the way a parent would expect them to. But, at a minimum, the child should be receiving what they received when they were living in the same house with both parents. So usually what happens, I'm going to just explain the process. So one parent would file for child support. They would have to file with the domestic relations office in their county. And then what will happen is the court will require each parent to provide about 6 months of pay stubs. And there might be other documents needed to determine that person's income. Okay, pay stubs are the average, but there could be others. So then you will go to a conference. It's usually scheduled 3 to 4 weeks from the time a person files, and you'll have a conference. So it's not called a hearing, it's called a conference. You'll meet in a small room. You'll give out all the paperwork to the divorce review officer, and what they'll do is they'll calculate a formula. And all of this is laid out online. Like, you could literally Google child support in Pennsylvania and figure out how to do the calculation, okay? But it's based off of parents' net incomes, and then there's a percentage that's applied. There's a chart where you could go in and see, how much of an obligation do I have to my child? And that formula changes based on how many children you have. Okay. And it changes on a lot of other things. Like if you're paying child support from a previous relationship, that comes into play. If you have a mortgage that's more than 25% of your monthly net income, you might get a credit there. There's little details that will be applicable to each case.
And I'm thinking too, so many people not only just work with the pay stub, but maybe they're independent contractors, maybe they're commissioned. I mean,
or what if they're working like under the table?
Exactly.
So there's a lot of those cases, and the divorce review or the conference, the support conference officers, they're keen to all of that. So the thing is that, if somebody's going to make an allegation like, oh, so-and-so is not working, but yet they know that that person's working on the side getting cash, you have to be able to prove it. But there is something that a support officer can do. So if there's somebody that comes into a conference and they say, I'm not working and I haven't worked for the last 6 months, but let's say they have a college education. Well, a support officer can assess them in earning capacity and say, okay, you're not working now, but you have a college education. And based on your education, this is how much you should be making per year. So that's why I'm going to assess you at that. And then they're going to be held to that obligation. So let's say somebody doesn't have a college education, but they're not working. They'll be assessed minimum wage. So even though they're not bringing any money in, they will be assessed a minimum wage so that will be factored into the calculation. So they might end up owing money even though they're not earning anything. And the purpose for that is to, one, deter people from trying to skirt their responsibilities.
Right.
Two, it's to get them back to work. So, it's not easy to relieve yourself of your obligation to support your children. At least in Pennsylvania and especially Lehigh County. I mean, they're very good support officers. They're extremely good at what they do, and they put up with a lot in a given day. So that's kind of the initial process. Once the support officer comes up with that formula, that recommendation, it's called a recommended guideline. And so they'll present that to the parents or the guardians, and they'll say, okay, do you want to stay at this number or do you want to negotiate a different amount? So parents have the opportunity to negotiate. Okay, they can negotiate up or down. You cannot waive child support rights though, right? You can't negotiate them away. So you have an obligation, but you can move the number up or down. I've seen it done both ways. After that, an order will be prepared and both parties will have it. It'll be an enforceable court order. So then what do you do after that? Most of the time, parents will go about their business, and the person who is paying is called the payor, and they will have their wages garnished from their paycheck. Okay, because it's in the system, everything's sort of electronic, automated at this point. So it'll go to the state, they'll process it. And one thing people should know is, like, if you file on March 1st, but you don't have your hearing until March 30th, the order will be retroactive to March 1st. Okay, so it'll go back to the day you filed, so you don't lose that 3 or 4 weeks. But, let's say the kids are young and things change. So a big question that pops up is, how do you change your support order? Well, we call it a modification. And, you can change a support order based on a number of things. Maybe your incomes change. Maybe you have a loss of employment or a gain of employment, or you have a child who wants to live with the other parent. Right. All kinds of factors. So that parent can petition the court for a modification. And then they would come back to the same conference officer and they would have a modification conference. And it's set up very similarly to the initial one. You'd have to bring pay stubs, supply all that information. Sometimes they ask for income and expenses. So they want to see how much you're spending, maybe on daycare, on childcare, on medical expenses. The more evidence you can bring to a support conference, the better off you'll be.
How much time can pass from the first order to asking for a modification? I'm wondering.
Well, it depends on the case.
Okay.
I I see people. I've seen parties file within weeks after the initial conference. Other people will go years. It just really depends. And so the payor is the person who pays the child support, right? That doesn't mean the payee doesn't have an obligation. It's just the payor either makes more money or makes the same, but the payee has primary custody of the children. And that means they have more overnights than the other person.
Mm-hmm.
So the person that has the most overnights is the one who's going to get paid the child support. So it really depends on each case. If you have a very contentious case and you have parties that don't get along, they might keep going back to court and fighting for more time. And if you get more time with the child, well, then you can file a modification to either pay less support or get more support.
Mm-hmm.
It can be really taxing, and when I say that the support officers put up with a lot, they see a lot. I saw one case where it was like every 3 or 4 months. The one parent was trying to reduce their obligation and they just kept filing and filing and filing. And then they weren't paying. So then there were contempt petitions being filed. Contempt is basically a violation if you're not paying your child support. And some support offices file them automatically.
Gosh.
Yeah, because remember that the wages are being garnished from your paycheck. So if you're not paying or if you stop paying, the state's going to know about it.
So how does this work out if you're in a mediation process? Do you use the formula? Is that how?
Yeah. So I mean, I personally think this is where mediation definitely is an advantage over litigation, because with litigation, this is what you do: you go to court, you fight it out. With mediation, we use the same guidelines. We come up with the same formula that a support officer would come up with. It's just my clients don't have to take time off of work. They don't have to go to court. They don't have to have their privacy invaded by having their paychecks garnished. And so, it's basically like an agreement. It'll be contractual. And we put the terms in our settlement agreements. So they're there and they can be enforced. It's just you go through contract law to enforce the agreement. You don't drag someone's reputation down by saying, oh, you're in contempt of court. And most of my clients, we don't have that issue where someone's not paying their support.
Can that, if things change, circumstances change, and you went through mediation, can you go back and modify that?
Yeah, absolutely. So child support is always modifiable. So is custody, for that matter. So, up until they're age 18 and age out, you can modify support as often as you want. I would say this, though: if you're modifying, because let's say one parent's getting, they're switching custody, physical custody of the child or children, I would recommend you go through custody first and have that agreement or court order modified, and then go to support court, because the support court's going to look at who has primary physical custody.
This is my last question on this, but can you go back to mediation process to do that and say, let's renegotiate this? We're changing custody. We're going to need to change support.
Yes, that's just a service that we offer, to help parents get, through the process. And, some of them start out and they have young children, and, as the child grows, there's different expenses and, like medical expenses. One of the things we do is we come up with the percentage of their obligation. So if the higher paid spouse has to pay 60% and the lower paid spouse pays 40%, when we do the support calculation, and there's out-of-pocket expenses, those are the percentages that we use. So the higher paid parent at that point would pay 60% of the expense, and the lower paid parent would pay 40%. But it's all based on the income.
Right.
So if people's income changes, I usually say, and the law says that it has to be substantial and material. So it can't just be like hey, I got a dollar increase, that might not move the needle on the support calculation. It has to be substantial. It has to be significant.
Like lost my job.
Yeah. Or I got a big promotion.
Okay. Other side of that.
So, and hopefully during these times, food's more expensive. I hear some people saying, I'm paying all this support. Where's it going? Well, food, clothing, and shelter is really expensive right now.
Right.
So the money you spent a year ago isn't the same amount today. It's going for a lot less because of inflation.
Right. Christina, this was a pretty in-depth conversation, and yet you really shrunk it down for us. So we appreciate that. But we got enough done that we really got a good feeling for how does this work with child support in Lehigh County and even in Pennsylvania in a lot of areas. So thank you.
You're welcome.
We need to ask you more questions. People may be calling in to ask questions, but we've got enough to get started. So thank you.
Happy to help.
And if you do have questions about this topic or any other topic, feel free to call the Alpha Center. You can ask for Christina. You can talk to anybody who answers that phone to get some good answers. Thank you. And Christina, thank you. And we'll see you back next month.
My pleasure. Bye, everyone.
Bye now.